Civil Procedure Reviewer. Rule 4. Venue of actions. Q. Define venue. A. Venue is the place or the geographical area where an action is to be filed and tried. In civil cases, it relates only to the place of the suit and not to the jurisdiction of the court. Manila Railroad Company versus Attorney General 20 Phil 523. Venue, not a matter of substantive law. Venue is procedural and not substantive. In civil cases, venue is not a matter of jurisdiction. Years of Pedro Lopez versus De Castro 324, SCRA 591, 2000. Venue becomes jurisdictional only in a criminal case. In the latter case, where the information is filed in a place where the offense was not committed, the information may be quashed for lack of jurisdiction over the offense charged. Section 3, R117. This is not so in a civil case where improper venue is not equivalent to lack of jurisdiction, because it is merely procedural. The parties can waive the venue of a case. Means of waiving venue. 1. Failure to object via motion to dismiss. 2. Affirmative relief sought in the court where the case is filed, even if venue is improper. 3. Affirmative defense in an answer. 4. Voluntary submission to the court where the case is filed. 5. Laches. Dismissal based on improper venue. 1. The trial court cannot motu proprio dismiss a case on the ground of improper venue. The court may motu proprio dismiss an action in case of lack of jurisdiction over the subject matter, litispendentia, res judicata, and prescription, but not for improper venue. Rodolph Glates Holding versus Register of Deeds of Paranaque City 344 SCRA 68. Universal Robina Corporation versus Lim GR 154 338 2007, October 5. 2. Unless and until the defendant objects to the venue in a motion to dismiss, the venue cannot be truly said to be improperly laid, because the venue, although technically wrong, may be acceptable to the parties for whose convenience the rules and venue have been devised. The trial court cannot preempt the defendant's prerogative to object to the improper laying of the venue by motu proprio dismissing the case. The Quique versus IAC 195 SCRA 641. When court may motu proprio dismiss based on improper venue. The court may dismiss on improper venue at its instance in an action covered by the rules and summary procedure. Under these rules, the court may motu proprio dismiss a case when an examination of the allegations of the complaint and such evidence as may be attached thereto on any of the grounds apparent therefrom. The dismissal may be made outright, which means that the court may do so without need of waiting for the filing of a motion to dismiss. Section 4, Rules and Summary Procedure. How venue is determined. As said before, in order to know the venue of a particular action, the initial step is to determine if the action is personal or real. If it is personal, the venue is transitory. Hence, the venue is the residence of the plaintiff or the defendant at the option of the plaintiff. If the defendant is a non-resident, the venue is the residence of the plaintiff or where the non-resident defendant may be found, at the election of the plaintiff. Section 3. If the action is real, the venue is local. Hence, the venue is the place where the real property involved, or any portion thereof, is situated. Section 1. However, when the defendant is a non-resident and is not found in the Philippines, and the action affects the personal status of the plaintiff, or any property of the defendant located in the Philippines, The venue is the residence of the plaintiff or where the property or any portion thereof is situated. Section 3. Venue of real actions. Section 1. Venue of real actions. Actions affecting title to or possession of real property or interest therein shall be commenced and tried in the proper court, which has jurisdiction over the area wherein the real property involved or a portion thereof is situated. Forcible entry and detainer actions shall be commenced and tried in the municipal trial court of the municipality or city wherein the real property involved or a portion thereof is situated. 1 letter A, 2 letter A, letter A. Why does the law say tried in the proper court? A. It is because proper court will now be the MTC or the RTC depending on the assessed value of the property. The venue is the place where the real property or any portion thereof is located. If a property is located at the boundaries of two places, file the case in either place at the option of the plaintiff. When the case involves two properties located in two different places. 1. If the properties are the subject of the same transaction, file it in any of the two places. And 2. If they are the subjects of two distinct transactions, separate actions would be filed in each place unless properly joined. Venue of personal actions. Section 2. All other actions may be commenced and tried where the plaintiff or any of the principal plaintiffs reside, or where the defendant or any of the principal defendants reside, or in the case of a non-resident defendant, where he may be found at the election of the plaintiff. Venue of personal action. 1. Where the plaintiff or any of the principal plaintiffs reside. 2. Where the defendants or any of the principal defendants reside, or in case of a non-resident defendant but found in the Philippines, in the place where he may be found. Note, all at the election of the plaintiff. Situation. Suppose there are 4 plaintiffs and 4 defendants, and the 4 plaintiffs reside in 4 different cities or municipalities. So there are 8 choices for venue because the law says where the plaintiff or any of the principal plaintiffs or where the defendant or any of the principal defendants reside. Note, principal plaintiff, principal defendant, because there is such a thing as nominal defendant and nominal plaintiff. Example of a nominal party. When a party wants to file a case to annul an execution sale or to annul a levy, normally it includes the sheriff as party. But the sheriff is not the principal party but is only a nominal party. So the residence of the sheriff is not considered the sheriff being a nominal party only. This is the original concept of forum shopping, which is legitimate but had later been abused. This is why there is a Supreme Court case where Justice Panginiban cited the history of forum shopping entitled First Philippine International Bank versus CA 252-259, January 24, 1996. How to distinguish real from personal action? There are instances when it is easy to distinguish whether the action is real or personal, and there are also instances when it is difficult. Example, an action for annulment of a contract of sale or rescission of contract of sale of real property. Generally, an action for annulment or rescission is a personal action, but suppose I will file a complaint to annul or rescind a contract or a deed of sale over a parcel of land which were made 1 year ago, which land is situated in Mandaue City, and the purpose of my action is to recover the ownership of that land. Is this a real or personal action? It is a real action because the primary object of the suit is to recover the ownership of real property. It seems to be personal, but in reality, it is a real action. So the venue is governed by Section 2. But there are also actions which appear to be real, but in reality are personal actions. like what happened in the case of La Tondenia Distillers versus Ponferrada, 264 Square 540. And this is the case. By the way, before I continue, please hit that subscribe button if this audio is helping you. It's free. It makes me feel good about myself knowing that I'm helping you, and it makes me feel good about you too. Cheers! Facts. A entered into a contract where she committed herself to sell her land to B. A even placed a lease pendants on the property, but later she backed out. So B will file a case against A for a specific performance to compel her to sign the deed of sale. Issue. Is this real or personal action? Held. It is a personal action because you are not questioning my ownership. Here, the plaintiff recognizes that the defendant is still the owner, which is the reason why he is still filing the case to compel him to sell. Thus, it should be filed at the residence of the parties. The complaint is one for specific performance with damages. Private respondents do not claim ownership of the lot, but in fact recognize title of defendants by annotating a notice of lease pendants. In one case, a similar complaint for specific performance with damages involving real property was held to be a personal action, which may be filed in the proper court where the party resides, not being an action involving title to or ownership of real property. Venue in this case was not improperly laid before the RTC of Bacolod City. Adamus versus Tuason, 25 Scra 30. Q. Where several or alternative reliefs are sought in an action, and the reliefs prayed for are real and personal, how is venue determined? A. Where several or alternative reliefs are prayed for in the complaint, the nature of the action as real or personal is determined by the primary object of the suit or by the nature of the principal claim. Thus, where the purpose is to nullify the title to real property, the venue of the action is in the province where the property lies. Notwithstanding the alternative relief sought, recovery of damages, which is predicated upon a declaration of nullity of the title. Navarro versus Lucero, 100 Phil 146. Where a lessee seeks to establish his right to the hacienda, which was subsequently sold for the purpose of gathering the crops thereon, it is unnecessary to decide whether the crops are real or personal property, because the principal claim is recovery of possession of land, so that he may gather the fruits thereof. LTC versus Macadaig. Residence of the parties. Where is the residence of the parties? Because residence in law could mean domicile or legal residence. It could be actual or physical residence. With the exception of only one case, the word residence and venue has been uniformly interpreted by the Supreme Court to mean actual or physical residence, not legal domicile. There are so many cases already, like Ku versus CA, 70 Squad 296, Fule versus CA, 14 Squad 189, Hernandez versus World Bank of the Philippines, 81 Squad 75, Raymond versus CA, 166 Squad 50, Esquerta versus CA, 193 Squad 54, except for one case decided way back in 1956, and that is the case of Corey versus Corey, 100 Phil 221. Facts. An American who resides in San Francisco who came to the Philippines rented an apartment in Manila to sue his wife, who is a Filipina. The wife is from Mindanao, and then the American husband filed the case in Manila because he rented an apartment in Manila. Held. You are not a resident of Manila. Your residence is in San Francisco. That is your domicile. So that is to compel the American to file the case in the residence of the wife rather than the wife going to Manila. So the case of Corey is the only exception where the Supreme Court said residence means domicile. All the rest, physical. In the case of Corey, maybe the Supreme Court there was just trying to help the Filipino. If we will interpret the rule on venue as physical, it is the Filipino who will be inconvenienced. Residents of a corporation. Under Rule 1, a corporation can sue and be sued. But what is the residence of a corporation? Under the corporation law, the residence of a corporation is the place where its head or main office is situated. Clavicilia Radio System versus Antolin, 19 Squad 39. The facts. Clavicilia was sued in Cagayan de Oro City. Clavicilia questioned the venue because its head office is in Manila. The plaintiff argued that it can be sued because it has a branch in Cagayan. Issue. Is a corporation resident of any city or province wherein it has an office or branch? Held no. Any person, whether natural or juridical, can only have one residence. Therefore, a corporation cannot be allowed to file personal actions in a place other than its principal place of business, unless such a place is also the residence of a co-plaintiff or defendant. The ruling in the case of Antolin was reiterated in the 1993 case of Young Auto Supply Company versus Court of Appeals, because the law said where the plaintiff or any of the principal plaintiffs. So if the corporation is suing with someone from Cebu City, even if its head office is in Manila, the corporation can file in Cebu City because of the residence of a co-plaintiff or the residence of the defendant. But outside of that, a corporation cannot sue outside of its head office because its residence is there. That is the case of Young Auto Supply. Or in the case of a non-resident defendant, where he may be found. Suppose the defendant is not residing here in the Philippines but is just on vacation and you want to sue him. What is now the point of reference? Did you notice the phrase, or in the case of a non-resident defendant where he may be found? Now, what does that mean? It means to say that the defendant is not actually residing in the Philippines, but he is temporarily around because he is found in the Philippines. Example is a balikbayan who is still on vacation. Problem. Suppose a Filipino who is already residing abroad decided to come back this Christmas for a vacation. When he landed at the Manila domestic airport, you met him as your friend, and the first thing he requested you is if he could borrow some pesos because his money is in dollars. He borrowed from you 15,000, promising to pay in a week's time. 1 week later, still he has not paid you, and obviously it seems he will not pay you. So you decided to sue him while he is around to collect. Where is the venue of the action? A. The law says generally where the plaintiff resides or where the defendant resides. The trouble is the defendant has no residence here because he is already residing abroad, but he is temporarily here in the Philippines. You can sue him where he may be found. If he decides to stay in Cebu, that is where the proper venue, rather his permanent residence. So where he may be found is the alternative venue. The phrase where he may be found means where he may be found here in the Philippines for a non-resident defendant but temporarily staying in the Philippines. Q. Suppose a defendant is a non-resident and he is not even here. For example, your neighbor borrowed money from you and the next thing you heard is that he left the country. He has already migrated to the States. Of course, you know his address there. Can you sue him in the Philippine court? A defendant who is no longer residing here and is not found in the Philippines? No, you cannot. Charge sheet to experience. So why can't you sue a person not residing here in the Philippines and not found here? Also, there is no way for Philippine courts to acquire jurisdiction over his person, otherwise he will not be bound by the decision. But in the discussion on the elements of jurisdiction, like the subject matter, person, res, and issues, res, or the thing in dispute, is important because sometimes it takes the place of jurisdiction over the person of the defendant. So even if the Philippine court cannot acquire jurisdiction over the person of the defendant, but the subject of the controversy or res is in the Philippines, then the non-resident defendant can also be sued in the Philippines. The court can now acquire jurisdiction over the rest, subject matter, and since the rest is here, the judgment can be enforced. It is not a useless judgment anymore. Example, he is the owner of a piece of land here, and you want to file a case to recover ownership over the land here in the Philippines. Can you sue the non-resident defendant? Yes. Under Section 3, even if the person is abroad, the rest of the property in dispute is here. And if he loses the case, the judgment can be enforced, transfer the property to you. So it is not a useless judgment. That is what Section 3 is all about. Section 3, venue of actions against non-residents. If any of the defendants does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff or any property of said defendants located in the Philippines, the action may be commenced and tried in the court of the place where the plaintiff resides or where the property or any portion thereof is situated or found. Q. What is the difference between the non-resident defendant in Section 2 and the non-resident defendant in Section 3? In Section 2, the non-resident defendant may be found in the Philippines, but in Section 3, he does not reside and is not found in the Philippines, so physically he's not around. Venue of ordinary civil actions against non-residents. 1. Non-resident but found in the Philippines for personal actions where the plaintiff resides or where he may be found at the election of the plaintiff. B. For real actions where the property is located. 2. Non-resident not found in the Philippines. An action may be filed only when 1. The action affects the personal status of the plaintiff and venue is the place where the plaintiff resides, or number 2, the action affects the property or any portion thereof. If said defendant is located here in the Philippines and venue is the place where the property or any portion thereof is located. Action that affects the personal status of the plaintiff. Example, a young child was abandoned by his illegitimate father. The illegitimate father left the Philippines for good. The son wants to file a case against the father for compulsory recognition, at least to improve his status. Q. Can the child file a case for compulsory acknowledgement here in the Philippines against the father for compulsory acknowledgement? Yes, because the action involves the person's status. The rest is the status of the plaintiff, who happens to be in the Philippines. The action affects the property or any portion thereof of said defendants located here in the Philippines. Example, the defendant who is already abroad owns a piece of land located here in the Philippines and you want to recover the ownership of the piece of land. What is the rest? The rest is the land which is situated here in the Philippines. Therefore, you can sue the defendant even if he is there because the court can acquire jurisdiction over the rest. In order to validly sue in the Philippine court, a defendant who is no longer residing here and is no longer found here, the action must be 1. Action in rem, or at least quasi in rem. In the example given, if the action is for compulsory recognition, that is actually an action in rem. And the suit which involves a property in the Philippines, at least that is an action quasi in rem. But if the action is purely in personam, then there is no way by which you can sue him. Example, it's an action to collect an unpaid loan. Question, where is now the proper venue of the action against non-residents? The law says where the plaintiff resides, action which affects the personal status of defendants where the property of the defendant located here in the Philippines. Section 4, when rule not applicable, this rule shall not apply. A. In those cases where a specific rule or law provides otherwise, or B. where the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. A. In those cases where a specific rule or law provides otherwise. What cases provide for venue of the action which may be different from what Rule 4 says? The following. 1. A civil action arising from libel under Article 360 of the Revised Penal Code. Libel could give rise to a civil action for damages. It is considered under the RPC as one of the independent civil actions. The criminal action for libel shall be filed simultaneously or separately in the RTC of the province or city where the libelous article is printed and first published, or B, where any of the offended parties actually resides at the time of the commission of the offense. If one of the offended party is a public officer whose office is in the city of Manila at the time of the commission of the offense, the action shall be filed A, in the RTC of Manila, or B, in the RTC of the province where he held office at the time of the commission of the offense. Number 2. Section 5, Number 4, Article 8 of the 1987 Constitution. The Supreme Court may order a change of venue or place of trial to avoid a miscarriage of justice, as what happened in the case of Mayor Sanchez. B. Where the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. The parties may agree on a specific venue which could be in a place where neither of them resides. Take note that the stipulation must be in writing, made before the filing of the action, and exclusive as to the venue. While the first two rarely pose a problem, the third has been a source of controversy in the past. A stipulation that any suit arising from this contract shall be filed only in Quezon City is exclusive in character and is clear enough to preclude the filing of the case in any other place. In this case, the residences of the parties are not to be considered in determining the venue of the action. How about a stipulation that the parties agreed to sue and be sued in the courts of Manila? Polytrade Corporation versus Blanco, 30 Scra 1981. Facts. C and J are both residing in Cebu City. J borrowed money from C and executed a promissory note in favor of the latter, which says, I promise to pay C the sum of 200,000 pesos 1 year from today. In case of a suit arising from this promissory note, the parties agree to sue and be sued in the city of Manila. When the note matured, J did not pay C, so C filed a case to collect the unpaid loan in Cebu City, but J challenged the venue on the ground that the venue is agreed upon, which is in Manila. According to C, the venue is correct because both of them are residing there in Cebu City, and under Rule 4, the venue is where I reside or you reside at my option if I'm the plaintiff. Issue: who is correct in this case? Held: plaintiff is correct, notwithstanding the stipulation. Why? When the parties stipulated on the venue of the civil action other than those found in the rules of court, the stipulated venue is considered merely as an addition to where the parties reside, unless the stipulation contains restrictive words which shows the intention of the parties to limit the place stipulated as the exclusive venue. So in the second exception, where there is an agreement in writing on the exclusive venue, the word exclusive is very important, as taken in the ruling in Polytrade versus Blanco. So if the venue is not exclusive, Rule 4 still applies, and the stipulated venue is just an additional option. Of course, there are stipulations where you can see clearly the intention of the parties to limit the venue, but sometimes there are stipulations in which it is difficult to see the real intention of the parties, whether exclusive or not. Examples of clear stipulations which calls for the application of the Polytrade ruling: in the city of Manila only, or the suit shall be filed in the city of Manila and in no other place. The Polytrade doctrine was further applied in the case of Unimasters Conglomeration versus CA 267 Squa 759. In this case, it was ruled that the stipulation stating that all suits arising out of this agreement shall be filed within the proper courts of Quezon City is only permissive and does not limit the venue to the Quezon City courts, as explained by the Supreme Court. In other words, unless the parties made very clear, by employing categorical and suitably limiting language, that they wished the venue of the actions between them to be laid only and exclusively at a definite place, and to disregard the prescriptions of Rule 4, agreements on venue are not to be regarded as mandatory or restrictive, but merely permissive or complementary of said rule. There must be, to repeat, accompanying language clearly and categorically expressing their purpose and design that actions between them be litigated only at the place named by them, regardless of the general precepts of Rule 4. And any doubt or uncertainty as to the parties' intentions must be resolved against giving their agreement a restrictive or mandatory aspect. Any other rule would permit of individual, subjective judicial interpretations without stable standards, which would, well, result in precedents in hopeless inconsistency. However, there are cases in which you cannot find the word exclusive or the word only, and yet the Supreme Court said it seems the intention of the parties to limit the venue as exclusive, as what happened in the 1994 case of Jesmundo versus JRB Realty Corporation. Facts: this involves a lease contract which contained a stipulation in venue. Here is the language of the lease contract. Venue for all suits, whether for breach hereof, or damages, or any cause between the lessor and the lessee, and persons claiming under each, being the courts of appropriate jurisdiction in Pasay City. In other words, if there is a case, they agree to file it in the court of Pasay City. Issue: is this intention of the parties to make Pasay City an exclusive venue? Held: Pasay City is the exclusive venue. It is true that in Polytrade Corporation versus Blanco, a stipulation that the parties agreed to sue and be sued in the city of Manila was held to merely provide an additional form in the absence of any qualifying or restrictive words. But here, by laying in Pasay City the venue for all suits, the parties made it plain that in no other place may they bring suit against each other for breach of contract or damages or any other cause between them and persons claiming under each of them. In other words, the intention of the parties is to make Pasay City the exclusive venue. The following stipulations were likewise treated as merely permissive and did not limit the venue. A. The agreed venue for such action in Makati, Metro Manila, Philippines, Manila versus CA. B. In case of litigation hereunder, venue shall be in the city court or court of first instance of Manila as the case may be, for determination of any and all questions arising thereunder. Philippine Bank of Communications versus Traso, GR 165500. Letter C. It is hereby agreed that in case of foreclosure of this mortgage under ACT 3135 as amended, and Presidential Decree number 385, the auction sale shall be held at the capital of the province, if the property is within the territorial jurisdiction of the province concerned, or shall be held in the city if the property is within the territorial jurisdiction of the city concerned. Langkaan Realty Development versus UCPB, GR 139427. Letter D. All court litigation procedures shall be conducted in the appropriate courts of Valenzuela City, Metro Manila. Auction in Malinta versus Luyaben, GR 173979. Examples of words with restrictive meanings are only, solely, exclusively in this court, in no other court save particularly, nor else but except, or other words of equal import. Pacific Consultants International Asia versus Sconfield, GR 166920 of 2007. Cases like Huestes versus Torres and Bautista de Borja and other rulings contrary to polytrade doctrine are deemed superseded by current decisions and venue. In Supina versus De La Rosa, 334 Philippines 671, it was ruled that hoist, or however you pronounce that, Hoechst, had been rendered obsolete by recent jurisprudence applying the doctrine enunciated in polytrade. This conflict was resolved in the cases of Philippine Banking versus Tensuan, where the Supreme Court ruled that the ruling in Bautista de Borja and Hoist versus Torres has been rendered obsolete by the polytrade ruling, and subsequent cases reiterated it. So the ruling in polytrade is the correct ruling. When stipulation would be contrary to public policy of making courts accessible to all who may have need of their service. Sweet Lines versus Tives. Facts. This is a Cagayan de Oro case which involves Sweet Lines, a shipping company with a head office in Cebu. The respondent Tives is the former city fiscal of Davao City, former mayor, and became judge of CFI of Cagayan de Oro. There was a group of passengers who rode on the Sweet Lines bound for Cebu City. During the trip, they were given a crude treatment by the officers of the vessel. When they came back in Cagayan de Oro, they filed a suit for damages against Sweet Lines. They filed a case in the former CFI, now RTC, of Cagayan de Oro, because the plaintiff are residents of Cagayan de Oro City. Sweet Lines filed a motion to dismiss, questioning the venue of the action because in the ticket issued by Sweet Lines, it is stipulated that in case of a civil action arising from the contract of carriage, the venue of the action shall be the city of Cebu only and in no other place. So there is a restrictive word. Obviously, the lawyers of Sweet Lines knew about polytrade because they moved to dismiss the case, citing this case. Judge Tives denied the motion to dismiss the case despite the stipulation. According to him, it is unfair. If I will dismiss the case based on this stipulation, the aggrieved parties will be discouraged in going to Cebu. It is very expensive and they will be inconvenienced, but if the case will go on in Cagayan de Oro, it will not inconvenience Sweet Lines because they have their branch office, their manager, and their own lawyer. Issue: whether or not Cagayan de Oro is the proper venue. Held? Yes. Judge Tives was correct in not dismissing the case. First of all, the stipulation is placed in the ticket. These people never even bothered to read this. That stipulation was pre-prepared, so either you take it or leave it. Therefore, the passengers did not have a hand in preparing that stipulation. So the contract is a contract of adhesion. Second, again for the sake of equity, to be fair, that these poor people will be compelled to go to Cebu to file a case there. They will be discouraged. It is very expensive to go back and forth to Cebu. Whereas Sweet Lines has the resources, the means, the lawyers in Cagayan to litigate. Therefore, it would be inequitable to compel them to apply the stipulation there. The ruling in Sweet Lines is an exception to polytrade despite the exclusive stipulation. The Supreme Court said that the refusal of the court to apply it is correct. There is no grave abuse of discretion on the part of Judge Tives. In the case of Arquero versus Flojo, 168-54, facts: Arquero is a lawyer and the municipal mayor of the municipality of Santa Teresita, Cagayan Valley. He sent a telegram through the RCPI branch in Cagayan addressed to a congressman stating, "I will go there to Manila. I will see you in your office on this particular date." When he went to the office of the congressman after a few days, who was mad at him, telling him, "So you're here to ask for a favor for your own, but your telegram was charged collect." Arcaro was stunned and embarrassed because he paid for the telegram. Upon his return to Cagayan, he filed an action for damages against RCPI. But in the RCPI telegraph form, there is a stipulation that venue of any action shall be the court of Quezon City alone and in no other courts. So the venue is restrictive, and RCPI filed a motion to dismiss, citing as ground improper venue. The trial court granted the motion. Arcaro went to the Supreme Court, citing the case of Sweet Lines, where despite the fact of a restrictive stipulation, Supreme Court refused to apply the polytrade ruling. Held. The ruling in Sweet Lines versus Tevis does not apply. You are bound by the stipulation. Why? Well, because you are a lawyer, so you know the implication of the stipulation signed. Q. Distinguish jurisdiction from venue. The following are the distinctions. 1. Jurisdiction refers to the authority of the court to hear the case, whereas venue refers only to the place where the action is to be heard or tried. Jurisdiction over the subject matter cannot be waived, whereas venue is waivable and can be subject of agreement. 3. Jurisdiction is governed by substantive law, judiciary law, BP 129, whereas venue is governed by procedural law, Rule 4 of the Rules of Court. 4th, jurisdiction establishes a relation between the court and the subject matter, whereas venue creates a relation between the plaintiff and the defendant, or petitioner and respondent. 5. Jurisdiction or lack of it over the subject matter is a ground for a motu proprio dismissal, while venue is not, except in cases subject to summary procedure. Bar question. State in what instance the jurisdiction and venue coincide. A. In criminal cases, because in criminal cases, venue is territorial jurisdiction. But in civil cases, jurisdiction and venue are two different things. They do not coincide. And before you go to my next audio, do me a favor and hit that subscribe button. It is an appreciation button that releases serotonin, which is also called a happy chemical.